Hello and welcome you all in the Legal Updates segment by The Law. Today again, we have two extremely important judgments for you. The first one is SUKHDEV Singh versus SUKHBIR KAUR, bench comprised Justices Abhay S. Oka, Ahsanuddin Amanullah and Augustine George Masih. Answering a reference, the Supreme Court ruled that permanent alimony and interim maintenance under the Hindu Marriage Act 1955 can be granted even when the marriage has been declared void. A spouse whose marriage has been declared void under Section 11 of the 1955 Act is entitled to seek permanent alimony or maintenance from the other spouse by invoking Section 25 of the 1955 Act. Whether such a relief of permanent alimony can be granted or not always depends on the facts of each and every case and the conduct of the parties. The grant of relief under Section 25 is always discretionary, the court held. The Supreme Court expressed its disapproval of the Bombay High Court in the same judgment that employed misogynistic language against a woman whose marriage was declared void, referring to her as an illegitimate wife or a faithful mistress. Under Section 21 of the Constitution of India, every person has a fundamental right to lead a life with dignity, the court quoted. Calling a woman an illegitimate wife or faithful mistress will amount to a violation of the fundamental rights of that woman under Article 21 of the Constitution of India. Describing a woman by using these words is against the ethos and ideals of our Constitution. No one can use such adjectives while referring to a woman who is a party to a void marriage. Unfortunately, we find that such objectionable language is used in the judgment of the full bench of a High Court. The use of such words is misogynistic. The law laid by the full bench of the Bombay High Court is obviously not correct, the court observed. Next is the case wherein the bench of Justice P.S. Narasimha and Pankaj Mithal in the case of the state of Maharashtra and others versus PRISM Cement Limited stated that every statute is prospective unless expressly stated otherwise. The Supreme Court says the 2002 amendment to the CST Act won't affect accrued rights. The Supreme Court today held that though after the amendment of Section 8, Clause 5 of the Central Sales Tax Act, the state government's right to grant exemption from tax has ceased to exist, the amendment is still prospective. Thus, it would not apply to the cases where an absolute exemption has already been granted. For more such quick updates, keep following The Law.